These four reasons are enough to send Nnamdi Kanu to jail. Malami speaks, turns down court's judgment. AGF Malami is the number one enemy of Nnamdi Kanu. And don't forget that he is the one that committed the error that the federal government are fighting to free themselves from. So what he's doing right now is just trying to see if he can be able to save himself from that very error. You know what he's going to pay. You know what they would levy him if Nnamdi Kanu leave detention. So he's just trying his best. Yes, let me just say that he's just trying his best, but his best will still not be good enough. You understand what I'm saying? So these four facts or four reasons that he is presenting, well, to me, I would say that he personally hatched that four reasons. Those four reasons are not genuine reasons. They are reasons which he personally hatched. They are not real reasons. They are not good reasons. He's just deceiving Nigerians with those reasons. You understand what I'm saying? And I just did. Okay, let's quickly check the content and know what Malami is trying to talk about. This is today's news. The Attorney General of the Federation and Minister of Justice Abubakar Malami has stated that the federal government is not ready to free the leader of the indigenous people of Biafra despite the court order requiring Nigerians to return him to Kenya and pay him 500 million as compensation. Malami stated in an exclusive interview with Vanguard yesterday that Nnamdi Kanu's rendition could not serve as the sole justification for the release of the IPOB leader from other charges related to alleged offenses against the federal government of Nigeria. The Minister of Justice indicated that the government was keeping Kanu in custody due to four significant reasons, the first of which was the rendition issue, which the court had already cleared him. Malami said, to release or not to release Nnamdi Kanu is a function of law and the rule of law for that matter. In deciding on whether to release or not release is one, you look at the rule of law. 2. You look at the public and the national interest. 3. You look at the security situation. 4. You look at international diplomacy. Let me talk first about the rule of law. This is someone that has been granted bail on account of charges that have been preferred against him at the court. Someone jumping bail to the international community. A case of a fugitive is established against the background of jumping the bail. 2. Arising from the national security. This is someone that is charged with treason, incitement, and destruction of civil authority, murder and assassination of other on account of his incitement that boils down to issues of national security and criminality. 3. On account of international diplomacy. This is someone that has against his person used the international community or a foreign country to launch an attack against a nation against its nation for that matter. So all these natural come into play to determine what to do. So if you have through judicial processes established multiple cases of treason, homicide, and bail jumping among others, the fact that you have indeed succeeded in one case as against multiple others that are pending goes to establish the fact that case cannot be the only basis and criterion for determining whether you are entitled to be released or not. Other than the case of rendition, which is indeed the only case that has been determined, there exist in the system other cases relating to jumping bail, other cases relating to inciting the public, other cases relating to murder, homicide, among others, and indeed above all. Within the context of the rule of law, the right of the federal government to challenge the decision that borders on rendition, a challenge associated with the appeal, a challenge associated with setting aside a certain judgment if the need for doing so arises, and indeed the multiple challenges within the context of the rule of law at the disposal of the federal government to exercise. The grammar is just too much. Yeah, you see, Malami is speaking to suit himself. Yes, that's what I think. He's speaking to suit himself. He's speaking to defend himself. All this that he has just listed now, the three judges that were first that were invited to pass the judgment brought out these things that Malami just is just saying. They brought it out. At the end of the day, these three persons, these three judges still came up with something favorable and declared Nnamdi Kanu free. Aside from these three judges, 21 judges were also invited. They also brought out these things that Malami brought out, and they still declared Nnamdi Kanu free. What are you talking about? Malami is speaking for his own justification and for his own personal interest. He knows is what the punishment that awaits him if he actually if Nnamdi Kanu dares leave detention. He knows. So let us just stop beating around the bush and let the IPOP leader leave detention. You understand? Yeah, he should leave detention because he has overstayed. He has served his own jail term and he has satisfied all that is necessary. Buhari said it that it's not going to interfere with the law. So why is he not interfering now? Let's hear from you from the outside, my dear listeners, on this that has just been taken note of. Don't forget your comments are still very, 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 very important. Don't forget to leave them below the comment section. Click on the subscription buttons as well as the bell buttons to get updated each time we upload any new videos. Thank you.